Yeah, on behalf of the second accused person, I had indicated in the morning the predicament we had in him appearing today. However, I do not believe that his absence would prejudice the proceedings of taking plea. We can go ahead and take plea in respect to accused one.
I'll read the charges.
Yeah.
Count number 1. The charge is conspiracy to defraud under section 217 Penal Code, and particulars are on or before the 9th day of December 2020 within the Republic of Kenya, jointly with the others not before court, conspired to defraud Mr. Ashok Shah and Ethan Kumar Amritlal Raja for parcel of land, known as land reference number 18485, IR number 640111, measuring approximate area of 7.39 hectares, situated along Lower Kabete Road, valued in Kenya shillings 1,350,000,000, the property of Ashok Shah and Ethan Kumar Amritlal Raja. Davis Chelogoi, true or not true?
Not true.
Not true. Count number 2. The charge is forcible detainer, contrary to section 91, as read with section 36 of the Penal Code, and particulars are on unknown dates between 9th December 2020 and 12th December 2023, along Lower Kabete Road within Nairobi City County, in the Republic of Kenya, being in possession of land, reference number 18485, Inland Register, that's IR number 64011/1, of approximate area of 7.39 hectares, situated along Lower Kabete Road, belonging to Ashok Shah and Ethan Kumar Amritlal Raja, without color of right, held possession of the said land in a manner likely to cause a breach of peace or reasonably apprehension of breach of peace against Ashok Shah and Ethan Kumar Amritlal Raja, who are entitled by the law to possession of the said land. Davis Chelogoi, true or not true?
Not true.
Count number 3. The charge is forgery, contrary to section 345, as read with section 349 of the Penal Code. And particulars are on or before the 9th December 2020, at an on time and place within the Republic of Kenya, jointly with intent to defraud Ashok Shah and Ethan Kumar Amritlal Raja of a parcel of land known as land reference number 18485, Inland Register IR number 64011/1, approximate area of 7.39 hectares, situated along Lower Kabete Road, valued at Kenya shillings 1,350,000,000, forged a certain document, namely a letter of allotment, reference number 75707, dated 31st January 1995, for land reference number 18485, Inland Register IR number 64011/1, purporting to be a genuine valid letter of allotment issued by the Commissioner of Lands. Davis Chelogoi, true or not true?
Not true.
Count number 3. The charge is forgery, contrary to section 345, as read section 349. And in particular, sir, on or before the 16th day of January 2023, at an on time and place within the Republic of Kenya, jointly with others not before court, with intent to defraud Ashok Shah and Ethan Kumar Amritlal Raja of a parcel of land known as land reference number 18485, Inland Register IR number 64011/1, of approximate area of 7.39 hectares, situated along Lower Kabete Road, valued at Kenya shillings 1,350,000,000. Forged the signature and stamp impression of Pauline Acheng Pesa, a land registrar with the State Department of Lands and Physical Planning, on certificate of title LR number 18485, IR number 232908, purporting to be a genuine and valid signature and stamp impression of Pauline Acheng Pesa. Davis Chelogoi, true or not true?
No.
Count number 5, uttering of which document, contrary to section 353, excluding section 349, and particulars of the charge are, on the 11th day of October 2023, at the Directorate of Criminal Investigations Headquarters, Masingira House, along Kiambu Road, within Kiambu County, in the Republic of Kenya, knowingly and fraudulently, uttered a forged document, namely, letter of allotment, reference number 75707/7, dated 31st January 1995, and a certificate of title LR number 18485, IR number 232908, bearing a forged signature and stamp impression of Pauline Acheng Pesa, to service number 80936, Detective Corporal Nicholas Ozuri, purporting them to be genuine and valid letter of allotment issued by the Commission of Lands and such, issued by Pauline Acheng Pesa, a land registrar with the State Department of Lands and Physical Planning, respectively. Davis Chelogoi, true or not true? Number 184. Those are the charges.
Diana, I have an application to make. We wish to apply for bond for the accused who were admitted to bail on terms of the court will set. Then two names that I need to establish. Under the Criminal Procedure Code, that's section 123, and under Article 49 of the Constitution, bond as a constitutional right is usually granted by the court once the party establishes, number one, the honor that an accused person has a flight risk and is diligent to observe the court. Number two, the court then will set terms of bond as commensurate to the charges that are before court. There are 2 points. Number one, Mr. Davis Chelogoi is a senior citizen of stability, integrity, and reputation, having served this country for over 35 years, in fact 40 in service. Previously served Your Honor as a district commissioner, in fact started as a DO way back in 1980s. Served in different countries, served as a district commissioner in Bureti and Nakuru, and deputy PC Nairobi. Before retiring in 2020, Your Honor, he was the coordinator of the wider Valley province, like an RCC, from the office of the president. Served as the PA to the head of public service for many years. You know, this is a man who has a track record and a man of repute, and who has sat in land boards, knows the systems. And Your Honor, just to briefly mention why these are charges that will be, this trial will go through a proper process. We will establish, Your Honor, that Mr. Chelogoi secured an allotment and a lease process in a normal manner, and they will demonstrate. Yes, I'll avoid. Yes. Your Honor, let me move to the point that he bears no guilt in terms of what is set out, but Your Honor, from the time the charges, the accused person was called to court, he has not been in good health. I have supplied, Your Honor, to show that the accused person was on a flight trip. So it's a record, his health record from Nairobi Hospital, where he has been attended to by Dr. Mwela Namasaka, severally. And Your Honor, the first time this matter was called to court, the accused person had traveled to Uganda on a visit without knowledge at the time that the case was coming up. That's the first time. The second time, Your Honor, when he came to court, the accused person was unwell, and I personally attended court and supplied records to the court, whereupon the court granted us the subsequent dates. Your Honor, the last time the matter came up for hearing, the court personally went to Nairobi Hospital, and it was at the instance of a third party that the court did not secure access to the hospital, even as we pleaded with authorities at that time. The accused person indicated, and we indicated to the court, and the record will show that we were ready for plea in hospital. Your Honor, we had planned, as I told the court previously, to come to court tomorrow for a plea, and the accused person was prepared for a plea. He cannot be a flight risk because he's a stable man with a family, with a known aboard, and is solid in all senses, Your Honor. Your Honor, the bail and bond policy should therefore be applied as interpreted with the Constitution on the granting of bail as a right. The accused person is of poor health, and that is evident. Even if you look at him, you can see he's sick. It's quite evident. I can see it myself. We pray, Your Honor, for two things: that you grant lenient bond terms to the accused person. We would have prayed for personal bond because they're a senior citizen and has rendered services to this country. But Your Honor, because you have another charge against the first accused person who has been admitted to bail, the second accused person, who has been admitted to bail on terms set by the court, we appreciate the court's hands may be tied to grant the same terms because of the provisions of Article 27 of the Constitution. We will have no problem, Your Honor, because we understand that we handle the court will check. But we plead, Your Honor, that this is an individual who will respect and attend court. He's not a small boy, he's a man who understands the process of the courts. He's served in administration and will attend court at his own instance. Your Honor, we will be ready to abide by the hearing terms that have been set by the court. Trial bundles having been served. So we'll be ready to proceed with this hearing as the court has determined. No prejudice will therefore be suffered by any person. And I'm glad that learned friend Mr. Mburu appears and is in court this afternoon. That will be all, Your Honor.
Granting bail for bond terms. Your Honor, my submission are that Your Honor, there has been no show of good faith, and I say good faith, by the accused person. Your Honor, we have mentioned this matter severally. And every time there has been an excuse and a reason given as to why the accused person couldn't take plea. even today, when the order was very clear that plea taking shall be on the 21st,
I think 22nd.
the order said 21st of March 2024. It was very clear, Your Honor. There was no show of good faith. Your Honor, the Constitution is very clear. Article 49, subsection 1H. Provides that yes, the accused person has the right to be granted cash bail or bond. However, if there are compelling reasons for the same not to be granted, then it should not be granted. And Your Honor, I also refer to the bail and bond policy guidelines. Your Honor, and in the same guidelines, court should also take judicial notice of the conduct by the accused person in granting bail or bond, and also, Your Honor, the seriousness of the offenses before court. Your Honor, should this honorable court be inclined to grant bail or bond, we pray that this honorable court only grants strict bond terms without the option of cash bail. And we also pray that the accused person deposits his passport to court. That is all.
Is protective of young advocates. And is also a senator. Good afternoon once again. I was here before you. The reason as to why I am seeking, I sought for this brief opportunity is that I continue watching these matters, all the complaints. And you know, if we ask the basic question, why are we having these proceedings a few minutes to 1 p.m. today? It is because on this 21st of March 2024, we were before you at the first accused did not show up in court. The counsel who was representing him confessed and confirmed that the order that unequivocally talked about today's session or plea taking was served upon them. So we can say at the very beginning, the reason as to why we're here this afternoon is because you issued a warrant of arrest against the first accused person. Basically, that is the circumstance within which we are here. You know, now, my conversation, my submission stems from there. If you look at a party who was forced to attend before you, courtesy of a warrant which you have under ruling, it was very candid this morning, who is before you? What are we looking at? We're looking at possible scenarios that the court has to consider if it's to be admitted on bond terms. The very first thing that we agree about is that under the Constitution is entitled to the same. But who are we looking at? We're looking at an accused party who, on the 22nd of December 2023, failed to attend this court. We are looking at an accused party who, on the 15th February 2024, failed to honor your court summons. We are looking at a party who, on the 27th of February again, that's the third time, 2024, failed to honor your court summons. We are looking at a party owner on the 12th of March this month, 2024, for the fourth time, a party who has not honored your summons. Now we are looking at a party who, Your Honor, on the 14th, this court now had to leave this particular premises just to go and pay him a visit. A circumstance that did not allow us to have an access to that particular hospital bed. Your Honor, when you look at these particular scenarios, what are we looking at? We are looking at the aspect of a party proving to be a flight risk. In other words, if plea taking has been this difficult for him to honor your summons, just to come and take his plea, Your Honor, how would you admit such a party bond or bail terms as such? That is the big question this morning, Your Honor. Your Honor, secondly, away from the aspect of flight risks, the second thing to consider if you are to grant him on either bond or bail terms is the risk that he will posit upon the witnesses. You look at the charge sheet, the first two witnesses are the people who I am watching brief for. It's Mr. Ashok Kumar and Detained Kumar Raja. Your Honor, the first accused party has a group of middle-aged men of about 21.
Let's not get there.
Yes, Your Honor, it's about...
That will be during the hearing.
Yes, Your Honor.
So let's not get there. Let's strictly
Yes.
adhere to bond and bail.
Very well, Your Honor. So what I'm saying is, the first accused party proves to be a risk and a danger to the witnesses who are supposed to testify in this court when we get to the point of admitting this matter to hearing. Your Honor, again, the first accused party who is before you, who seeks your clemency or your indulgence to admit him on any strict or bond or bail terms, has not been subservient to your court. So the big question is, why would your court be easy on him when on the 22nd December he has crossed the Kenyan borders to Uganda? Your Honor, for us, as we continue watching brief for the victims, we are looking at your court with clean, open eyes. We know how much you are committed to having this matter proceed. We know how the first accused has been unfair to the second accused in terms of court attendances. Your Honor, he may be a senior citizen, but he's a member of the public when he's in this court, just like any other person. Let us deal with him just like we would have dealt with our Jiku or a Robert somewhere. So, Your Honor, on that note, do not admit him to any bond or bail terms. I think he should serve, he should be in detention until we get to the point of hearing. That is our kind request. So that, Your Honor, any parties who are facing such counts under your charge sheet, this will be a lesson. This is something that the entire country is following. There's a lesson to draw. And I think potential Kenyans, Your Honor, who may end up finding themselves where he's finding himself in, have to have some lessons to draw from this court. Your Honor, let us deal with this matter in the strict sense that it deserves us. That's all.
Yes, Your Honor, in brief response. Your Honor, I'm reading through the order issued by the court. The order that I have not seen myself indicates, like, Your Honor, at order number 3, order number 1, that the accused person, Chelogoi, attends court in whatever circumstances, as the first order, yes, order number 1, it's here by order, yes. In whatever circumstances as to be advised by his doctor and if still admitted or obstro, the third respondent then his doctors to present him at the remanding court for plea on or before 22nd March. Then 22nd March is tomorrow.
Number 5?
Number 5 is...
Number 3.
Number 3, the matter we mentioned on 21st, which is, it was 22nd, then it's 21st.
Yes, before the signature.
Yes,
And
before
it
the...
has not been countersigned, again it was 21st. Because what was said in order 1, on or before the 22nd,
Yes.
and the courts will actually concur because, you know, I was for the JSC,
Yes.
and that is why we had to put the dates when immediately after I was done with JSC, and the order was brought to me, and I said, let's put it on the 21st.
Yeah,
So
unfortunately.
it is 21st.
So you don't have the advantage of knowledge. I think that is
I will not, it's not you I'm putting strict proof, but your law firm actually received this on the 20th at 16:12 hours.
Yes,
The first page, on the face of the application.
Yes, Your Honor, at the point, just to submit, at the point I knew of this order, which was yesterday, and I was informed of the order, I quickly informed my client, and we agreed that we would present ourselves for plea. In fact, I didn't know about 21st, I knew about 22nd. For some reason, that is what went to my mind, and I was just learning of the 21st today, I must confess. So, Your Honor, inadvertence of counsel would be on our side in terms of the date. Our reading was that we present ourselves for plea tomorrow. I prepared him for tomorrow. And so today, Advocate Nasa came to court, he had called me, told me we must get Mr. Chelogoi to appear in court today. That's an expression of good faith on our part. We did to stop what I was doing, to run and to look for him. Your Honor, in terms of all that my friend Mr. Ashok has said,
Not Ashok. Bashir.
Bashir, yes.
I don't know why you keep on.
I don't know why, I think I need your name.
Your client is Ashok.
Yes, Your Honor, Mr. Bashir,
Okay.
it is clear that no affidavit has been sworn by the prosecution on the possibility that these accused persons are fighters. At the time the first plea was taken in last year, Mr. Chelogoi was already in Uganda days before the plea was taken. He was not aware. The next time, Your Honor, this matter came up, we've exhibited medical records that have been verified by the investigator. We are not, I do not think that a man of this age would engage in monkey business. Other than health, his health reason is why he did not attend. I advised and would have taken plea much earlier. I did be in a position to attempt. Your Honor, if you even look at this, I'm a layman, but the kind of blood pressures that you see here were 90. Are crazy. You wouldn't even be in a position to walk. Your Honor, the provisions of Section 123, Article 49, and the Constitution now makes bail an absolute right. Absolute, of course, except that the court may, under the guidelines, temper that right, but not to take it away. So the right should and ought not to be taken away through punitive terms. That is what the various decisions of cases of value before the court find. In as much as my learned friend submits Mr. Bashir, that the court should deny bail, I don't think it would serve the complainant in any measure if my client is detained. It does not serve their interest. Their interest is to have the case had expedited and had so that they get their justice, if at all that justice exists. At this point, Your Honor, justice is a two-edged sword. It lies both for the first accused person and for the complainant. Is to ensure his attendance to court. If he fails to attend court at a date that the court will fix, then the court would cancel the bail and put him in. But we are not there yet, Your Honor. So let us not preempt. This old man who looks very harmless, I can look at his face, that he will disobey the court. He's a serious man. He's a senior man, but he's also sick. That's all. May I pray that you, at least you, because of her, that you, if at all Your Honor directs, maybe it will then be admitted to hospital pending.
Where it is, I'll just put a ruling that the ruling will be on the 25th of March, 2024 in
Yes.
the morning.
Yes, Your Honor.
I really don't want to get into that.
Your Honor, we find my
Just a
process
minute,
is
just
just
a minute. Sure?
Yes, Your Honor.
Just a minute. I don't want to start getting into the nitty-gritties of all these things. I
Yes.
will give a ruling on the 25th of March, 2024.
You know what will happen?
Yes, Your Honor, because
Just a minute. And I know now the next question will be, where will you be put? Earlier on, there's a warrant of arrest. I have not mentioned anything about that. There is a warrant of arrest, I have not mentioned. I'll say I'll give for bond and bail 25th of March. Should I also now execute where I should be taken?
Thank you, Your Honor.
no, Your Honor, normally when an accused person has a health status, normally the court may direct that.
Counsel, I
Pending.
don't deny, I say this with all humility.
Yes, Your Honor.
I don't want to get into that, and if I say anything more than that,
Yes,
then I'll be getting into the nitty-gritties of this matter. Where we are at,
Yes,
it's also not good, it's not also very easy for me about it. But I will definitely give a ruling on the 25th of March about the bond campaign. As to where he is going to be taken, I will not want to delve into that. And why I don't want to mention that, because this case already is building a history. So I will give a ruling on the 25th of March, 2024.
Your Honor, what time?
With your kind permission, Your Honor, perhaps I would seek the,
In the morning, I pronounced myself
yes,
that for your accused two, we have a hearing date.
we have a, 9th of April. So his
So we
attendance.
are done with him.
Thank
He
you
has a
very much.
hearing date, you have the document.
Thank you very much.
Yes, for this one, I give a ruling on the 25th of March and 2024. Council, senior council, just as you have directed and also made your submission, that I also, in favor of your client,
Yes, sir.
that I should also see that, that's accused one.
Yes, accused one.
What is
He's the accused one. This is accused two.
Accused two.
Yeah.
Yeah, and what I gave as the bond terms for accused two.
Yes.
Should also be considered.
Yes, yes, yes.
Yes, and that is why, because you are in this matter,
Yes.
I don't want to delve in that, but I will equally consider that.
Yes, yeah.
And even when he took me, I retreated. So my ruling will be pronounced on the plea.
Yes.
Allow me to say this, usually when somebody takes plea, the court does not further direct. The court directs itself to what is before the court, which is an application for bond and bail. It is not an application where the accused, now he's an accused.
Yes, yeah.
And yeah, because it's now before the court and he has taken plea.
Yeah, and I
But the
said-
court does not take, does not further direct where an accused person who has taken, you know, so you know what happened.
No, we,
Let me not get into that because that is not an application before the court.
we know, okay, we normally apply, Your Honor, where in these situations, we normally apply at least where there's a health situation concerned.
I was avoiding that
Yes.
because we just come from the hospital. You
Yes.
know what happened.
Yes.
I have seen the application that we had and I can
Yes.
see now Nairobi Hospital was involved.
Yes.
It would only be fair enough that Nairobi Hospital would have not been on the door.
Since we didn't want, we are able to
And
bring
that is
him.
why I don't want to make an
with the doctor.
application on something which is not before the court.
Your Honor, I think to be clear, when a party takes plea and is not admitted to bail there and then, even as he awaits ruling, it's basic, he should be in detention. You know, we should not be tiring him.
No.
I think that is what will follow after this. That's clear, Your Honor. I think that's what we're avoiding, but it's clear. After the court that was issued in the morning stand, Your Honor, that is what the court has stayed away from. So that is the position, Your Honor.
You know, we have, now that my friend is raising that
It's a
question,
clear position.
maybe it's an issue that the court would have dealt with.
It has done with the man.
Let me just leave it at that. I will have too much back to the court. I don't want to get into like if Nairobi Hospital, they are the only people who have come and told
one,
Yes, and you and I will attest that the court also took judicial notice. I did not know where the court was going to last week when you asked that the court be there, and that was the position. So allow me to say this, that the ruling will be delivered on the 25th of March.